when people file an insurance claim, I think we're all used to now where the system has become very adversarial, where even some courts have gone so far as to say that the interaction is an adversarial process. And the truth is that that's not where insurance developed from. That's not how it started. That's not what all the books say about insurance and insurance claims handling. It's not even how adjusters are trained. Today, they're trained to handle claims actively, proactively. They're supposed to proactively investigate claims and information. But what we often see is insurance companies just kind of look within the four corners of their own file, and if it's not there, they decide that the investigation hasn't yielded any reason to pay a claim. Those are the kinds of backgrounds that we have at Turbak Law Offices, looking at a lot of claims, and some properly handled, some improperly handled. There's this overall duty called the duty of good faith and fair dealing. And it's in all contracts as a matter of law, but it's only actionable in insurance contracts. So if a company breaches the duty of good faith and fair dealing, sometimes the shorthand verbiage or wordage is that they've committed bad faith. They've acted in bad faith by not protecting their insured claimant somehow. They failed to investigate. They failed to properly consider proof and losses submitted to them. They failed to timely pay the claim after they've had proofs and losses. And ultimately, the jury will be asked at the end of trial whether the company had a reasonable basis to deny the claim and whether the company knew or should have known that it lacked a reasonable basis. Those can be tough things to demonstrate because the company is obviously always pointing to a medical opinion that they may be hired, or they're pointing to a fact that the roof is 10 years old at the time of the hailstorm. There's always something that gets churned up as to the quote reasonable basis. When a company doesn't have a reasonable basis and the jury says that they don't, those can be important claims. They're important claims not only because the person who's injured, who maybe has to go to the nursing home or assisted living, or the person has a bad roof now, gets their claim paid, but the costs associated with bringing the claim, expert fees, additional contractor costs, if the fact that the roof didn't get repaired in time caused additional interior damage to the home, to some extent if there's physical damage to the person, if an elderly woman is very upset or distraught because she can't have the assisted living care under the policy she paid for, if she has to sell farmland to go and try to pay for her own care when the policy was supposed to pay for it. Those are all additional damages that are kind of beyond the initial purview of the contract. Because bad faith is a tort, which is a wrong, because that's a specific additional wrong, it carries with it additional damage or damages that the jury can allow for in their verdict. So those are important cases for that reason, because it can make the person not only have their claim paid in full, but it actually allows them to kind of get more made whole in terms of where they were before the loss. Even more important yet, what we see often is that claims aren't often not denied just as a matter of happenstance. There's often reasons. Some of the most common reasons that we see are poorly trained adjusters. Sometimes the adjusters are trained to only look at facts and proofs in their file rather than go outside and talk to the neighbors, talk to the contractors, those kinds of things, talk to the medical doctors. The adjusters just choose to not investigate because if they investigated, they would find facts that supported the loss. They might also find facts that didn't support the loss. But as a matter of choice, many adjusters just choose not to investigate so that they don't have any support in their file, so they don't have to pay the claim.